Excellent. All right, good morning, everyone. We've officially got the recording going. Thank you so much for joining us today. I am Kathryn Walker, Assistant Director at the Women's Business Center of Northern Virginia. Welcome to Trademark 101, Basics for Entrepreneurs and Small Businesses. This is going to be facilitated by Tammy at the Geller Law Group. Before I hand things over to Tammy, let me share a little bit about some upcoming Women's Business Center trainings. So later today, we're going to have Record Keeping Basics. This is a collaboration with M&T Bank. We've got Registering Your Business in Virginia and DC. That's when Tammy's going to return with us next week. Government Contracting, Digitalize Your Sales to Improve Performance, and Franchises, What's New and What's Next. And I'll be sure to include the registration link for those. They are free webinars at this time. For logistics for today, I'm going to recommend utilizing the questions box. It makes it easy so Tammy can see that questions are coming in, but I'm going to assist her and monitor the chat and the questions box throughout today. We'll work to address questions throughout the webinar, so you don't need to wait until the very end. And we will be recording today, and I can make that recording available. So for today's speaker, Tammy is with the Geller Law Group's business practice. Her practice focuses on providing business services to small businesses and nonprofit clients. She also manages the firm's trademark practice, assisting and counseling clients on trademark clearance and enforcement, and through the process of preparing and executing the trademark application. So she brings excellent experience today, and then we've worked with Tammy for a while now. She also does the registering your business topics, etc. So she well understands the voices of our clients and our small businesses in the region. So again, with that, I'll monitor the chat and the Q&A, and I'll officially hand it over to Tammy. Tammy, thank you so much for your time today.
Thank you, Kathryn. Good morning and welcome, everyone. It's so good to have you, and it's so great to be here to talk to you about trademarks. Thank you, Kathryn and the Women's Business Center for having me back. I always enjoy doing these webinars and being able to share information and also get information about businesses and questions that people might have, because often those are common things that come up with all businesses, and so it's helpful to share and create that sense of community and information exchange. So I'm gonna try to advance my own slides here, so hopefully everything goes according to plan. So here, this one, there we go. All right, so of course, as an attorney, I am compelled to provide you a disclaimer at the beginning of all presentations. So please note that this presentation is for informational purposes only and not intended to convey or constitute legal advice. It doesn't create an attorney-client relationship, and it's not intended as a solicitation or all-inclusive statement of the law. And if you need legal or professional advice about your specific case, please contact a qualified professional, whether that's an attorney or someone else who could be able to help you assist with the specific facts that you have concerning your case. All right, now that that's out of the way, we can start with an overview of what we're going to talk about today. First, I'm going to just talk generally about intellectual property, because that's just kind of, and give you the landscape of and context of what we're talking about with respect to trademarks. Then we're going to hone in on trademarks, talk about some definitions, what those, and the purposes of a trademark. And then we'll talk about what can be a trademark and some different aspects of trademarks, like common law versus registered trademarks. And then I'm going to walk you through the registration process, which is available to everyone. The Trademark Office does do a good job of putting information out there, but it can still be challenging, and folks often run into some snags here and there. So I'm here to give some tips and tricks for you, and hopefully if you're doing this on your own or have questions, I can answer those for you. And then finally, we'll wrap up with some post-registration considerations and other things to think about with respect to trademarks and intellectual property kind of more broadly. All right, so intellectual property. What is it? Often it's abbreviated as IP. So I'm going to use intellectual property and IP interchangeably throughout the presentation, but it means the same thing. The World Intellectual Property Organization, or WIPO, defines intellectual property as creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. IP refers to the intangible assets that differentiate your business and may encompass everything from your company's name, brand names, logos, slogans, innovative technology, or proprietary designs, recipes, or processes. IP is a key driver of economic growth and innovation in business. And in this world where everything's online and we're constantly competing with others, because the internet has really opened up the marketplace, IP protections really incentivize businesses to keep pushing for new advances because they know that their ideas and creations will be protected. Consumers, on the other side, trust IP to provide them with safe and authentic goods and services. So if they recognize the company or recognize the technology, they might be inclined or not inclined to patronize that company based on what they know about the company through their IP. So now we'll talk a little bit about the types of intellectual property. There are 4 main types of IP. You've probably heard about them all before, and you've certainly seen them in your daily life. And they are copyrights, trademarks, patents, and trade secrets. There are different functions to each type of IP and different protections for them under the law. And so the first one here on the slide is copyrights. Copyrights protect original works of authorship, and they're things like literary, musical compositions, motion pictures, sculptural works, software, architectural plans, and there's much more that can be protected by copyright. They have a long but limited life. So copyrights are in place for the life of the author, so whoever created the work, plus 70 years, or if it's a work made for hire, it is, there's a longer duration. It's 90 years from publication or 120 years from creation. So copyrights expire at a certain point, but it's a long timeline for expiration. So things like classical music, a lot of those composers have passed on, and so those copyrights are no longer in place. So that's why there's free recordings and like use of classical music, because those are in the public domain now. Trademarks identify the source of goods and services, and with continued use by the trademark owner, they can last forever. So as long as you're using a trademark or a business is using the trademark, and some companies last for a really long time, you can keep your trademark protection. Patents are government-issued monopolies for new and non-obvious inventions. So these are things like functional features of a process, machines, manufactured items, composition of matter. And patents can last 20 years from the date of the application when you file it with the USPTO, which is the United States Patent and Trademark Office. I don't practice patent law because anybody who's a patent lawyer has to take a separate bar and also have a scientific or medical background. So it's a very specialized area of the law because there's a lot of technical details involved in prosecuting a patent. So that's going to be something else that another type of attorney can handle for you. Trade secrets are formula, practices, recipes, processes, customer lists, things like that are protected and maintained as secret information in a business. So these are things that don't ever get shared publicly. The first 3 things on this list, copyrights, trademarks, and patents, there is a registration process for all of these types of intellectual property. Trade secrets, you don't register them because you want to keep them secret. Even within the operations of your business, no one person should have all of the details of the whole secret. So these are things like the recipe for Coke or the 12 herbs and spices for KFC's chicken. So nobody should be, publicizing these. And these are very valuable things because they can be the basis for which a business, on which business can make money. Okay, so now let's turn to trademarks in particular. The definition of a trademark is a word, name, symbol, device, or any combination of these that is used to identify or indicate the source of a good or service in the marketplace. So when a consumer sees this trademark, they recognize the business that it comes from, or the business or its goods and services in the marketplace, and it helps them distinguish these from its competitors. Trademark can refer to both trademark and service marks. Trademarks are marks that are used with goods. Service marks are used with services. But the term trademark, it's a little bit confusing, can refer to both trademarks and service marks. So it's kind of an umbrella term, but trademarks can also just refer to the goods, a trademark for goods offered in the marketplace. A trademark has two basic functions. It protects consumer expectations. So that means it prevents consumer confusion, fraud, or counterfeiting and passing off. And it indicates consistent quality for your consumers. Additionally, trademarks protect the trademark owner's investment. It gives the owner control over the goodwill and reputation represented by the mark. So what can be a trademark? There are a lot of things. Here we go. It can be a business name, a business logo, a brand name, a product name, a slogan or a tagline, a trade dress, a hashtag. Hashtags were kind of all the rage in 2016. That's when the Say It with Pepsi and the Cokes, Smile with a Coke hashtags came out, and everybody was rushing to register trademarks for hashtags. That's not as common anymore, but it was kind of a thing that kind of came and gone. You still can register a hashtag as a trademark. It can be a sound, such as the MGM lion roar, the NBC chimes, or McDonald's 5 notes, the ba-da-ba-ba-ba. That's also a registered trademark. It can be a smell. The smell of Play-Doh is a registered trademark. They just registered that in 2018. It can also be a color. Tiffany's blue is a registered trademark for the company. So whenever anybody sees this blue, they would associate it with Tiffany & Co. So there are a lot of things that you can use as a trademark, so long as you're using it to identify your business as the source of goods and services in the marketplace. So one aspect of trademarks that we should cover is what is a common law trademark versus a registered trademark. In the US, trademark protection begins when a mark is used in commerce. This is known as a common law trademark. So not all countries have this first to use law. In some countries, it's whoever's first to register a trademark has seen more superior rights. But in the US, it's when a mark is used in commerce. So a common law trademark, it's unregistered, but the rights are geographically limited and they're not as easily enforced as a federally registered trademark. Because of these geographic limitations and difficulty with enforcement of common law trademarks, it can be a challenge in an environment where everybody's online on social media and has websites and are accessible by potential customers everywhere, because there could be consumer confusion. Somebody in California might have the same mark as somebody in New Hampshire and are operating the same type of business, but if they both have a website, consumers could potentially get confused. So having a common law trademark, while it does give you protection, it doesn't give you the best protection. Especially in today's business environment where everybody has an online presence or is expected to have one. I find, if a business doesn't have an online presence, consumers often question, is this a legitimate business? So it's almost like peer pressure to have an online presence. And so this kind of creates this issue of common law trademarks being difficult to enforce, but there could be more confusion because everybody can see businesses all over the country. Common law trademarks may be indicated by using the TM symbol. I'll talk a little bit more about this on the next slide when I talk about registered trademarks. We've all seen the little TM superscript beside a word or a logo. So that's the trademark owner indicating that they're using that word or words or design as a trademark. Okay, so we've talked a little bit about common law trademarks and why they're not the best protection. So the other option is to register your trademark. In the US, you can register your trademark with the US Patent and Trademark Office. There's two sides of the USPTO. There's the patent side, which I do not deal with, and then there's the trademark side, which I'm very familiar with. So once it's registered, it becomes a registered mark, and you get all of the benefits of having a registered mark, because the trademark registration process can be pretty rigorous. And if your mark can withstand the process and pass examination, then you establish your trademark registration, and that gives you additional rights under the trademark law. So registration does things like establish a public record and provides public notice of important facts relating to the ownership, dates of use in commerce, and the types of goods and services offered in association with the mark. It also establishes other things, but those are the big significant things that you have to put into a trademark application. Registration provides national protection for the mark because you're registering it with the USPTO. That's a federal office, and trademark law is federal law. There are some state trademark registries that you could register a trademark with, but of course, those are limited to the protections under state trademark registries are limited to the state where the registry is. So if you do want to register a trademark, I think it's, whenever I do trademark registration, it's always at the federal level. Once you register your trademark with the USPTO, it provides national protection for the mark and allows enforcement of the owner's trademark rights in federal court. And it helps you do other things like if you have products on Amazon or other retailers, you can register your trademark with them. And so they can help you authenticate your products and help prevent trademark infringement by any other sellers. So there are things like that you can avail yourself to if you have trademark registration. And then another thing that trademark registration with the PTO can do is it can be used as a basis for trademark registration in other countries. So while you have trademark registration in the US, it doesn't mean that if you sell your product overseas that it's going to be a protected trademark over there. So your registration in the US, there are treaties between countries, including the US. And if there's a treaty, you can use your US registration as the basis for registration in another country. And then the last thing here is kind of important. It's significant. People might not know this, but only registered trademarks can be indicated with the R in the circle symbol. So if you have a trademark and you're using the trademark, but you haven't registered it, you can only use the TM symbol to indicate it as a trademark. Once you've completed registration, that means all the way through the process and you get your certificate, then and only then can you use the R in the circle on your materials. There are so many steps in the process that I often get questions like, okay, it's past this step. Can I use the R in a circle now? No, you can't. You have to wait until you get their certificate, because I've seen marks be close to registration, like they're at the last step, but then something happens and there's no, it doesn't go through. So there are some penalties for using the R in a circle because it is under the FTC, you need to, it's about truth in advertising. And so if you're using the R in a circle, you better have your trademark registered with the PTO. Otherwise, you're giving consumers the wrong idea about your trademarks. So that is common law versus registered trademarks. So hopefully I've convinced you that registration is a good idea. If you can, if you have the time and resources to register your trademark, I think it's always a good idea. The trademark process can be pretty lengthy, and we'll talk a little bit about that. But just as an overview, here are kind of the general steps involved in registering your trademark. So first you have to choose a mark. Then you do a trademark clearance search. I'll talk a little bit more about these steps in the subsequent slides. And then the trademark prosecution process. Prosecution is just the fancy word that means the trademark registration process, and you're taking it through the process. And so there's 4 main steps here. And then finally, if you are able to register your trademark with the USPTO, you have to maintain your mark. So choosing your mark, it's hard to choose a good mark. And that's why there are marketing people out there. Sometimes clients ask me if I have ideas for good marks, and I don't. Once you choose your mark, though, I can let you know if it's protectable, and then also help you register it. But please don't ask me to help come up with ideas for it, because I'm not that great at it. It's hard to choose a mark, or a business name or a brand name or something to convey and identify your business. You want it to say certain things about your business, and you want it to be memorable. But there are certain guidelines that you kind of have to keep in mind when choosing your marks, and we'll go through them, some of them now. So there are a couple of questions to answer. Does this mark infringe on someone else's trademark rights? And then also, am I investing in a mark that I can own? This is important because you want to be able to, so these are kind of same questions, 2 sides of the same coin. Does this mark infringe on someone else's rights? If you are infringing on someone else's rights, you might receive a cease and desist letter from the more senior trademark owner who has already been using the mark. Those sometimes escalate into litigation, and if the trademark owner wants to defend their rights and feels that your use is problematic, they can file a trademark infringement claim. It could also lead to a costly name change, where you have to change your name if your mark is the business name or your brand. If you ultimately need to make that change because of a trademark infringement claim. And then on the flip side, am I investing in a mark that I can own? Is there a crowded field of marks? And what that means is this a mark that is commonly used in this industry? For example, the word sunshine is used a lot in like daycares, or photography. There are a lot of photographers who like to use also sunshine or light or something like that in their name, and so those tend to be riskier in terms of using that as a trademark, and it might prevent you from registering your mark if there are a lot of people using that mark or elements of that mark in their names, and they're providing the same or related goods or services, because that could create potential consumer confusion, and that's what the trademark office is trying to prevent. You want to have a distinctive mark. Is the mark too generic or descriptive to warrant trademark protection? We'll talk about this a little bit more on the subsequent slide. These are things you want to consider and avoid. So the bottom line is that your trademark needs to be unique from other marks used in association with the goods and services that are similar or related to those that you're going to be offering. Here are some other factors to consider. So whether it's distinctive and whether it's a strong mark, that's kind of a trademark term. The strength of a mark is determined by its distinctiveness and some other factors as well. whether it functions as a trademark. So I've said a few times already that a trademark is used to indicate the source of goods or services. So sometimes folks have something that they want to put on like a shirt or items. Those might not necessarily be functioning as a trademark if it is just a design on a t-shirt or a slogan on a t-shirt. Does it indicate the source of goods and services, or is it just a cool slogan or cool design that you put on a shirt? The PTO will say that's just ornamental. It's not functioning as a trademark, where if people see it, they're going to recognize it as something that your business has put out. We already talked about the crowded field issue. And then there are other factors considered, just kind of business related outside of the trademark realm. So do you have domain names available for the mark that you want to use, if you need a domain name? And then, things like social media handles. So those kinds of things, even though they're outside of trademark, are very relevant in determining your trademark, because the trademark is something that you're going to use to market your business and your goods and services. So these are kind of all folded in together when choosing your mark. So there are different types of trademarks. And as you can see from the heading here, word, design, and composite marks. So we'll talk about each of them in turn. A word mark is a mark that's comprised of one or more words. It's the plain words. And the trademark office calls these standard characters. So that means there's no claim to any sort of stylization. So you're not saying this has to be a specific font. It's not a specific color. It's just the words. This is the most versatile type of mark because the words can be depicted in any manner if you are able to get it registered, because that's your mark, those words in the order that you have in the mark. Whenever I'm counseling clients and they have limited budget in terms of what they can spend on trademark registration, if it's available, I always recommend doing the word mark, because that's something that's spoken and written, and something that people, when they're talking about your business or your product, they can say it and they can write it. A design is not so easily conveyed. And there are other limitations with design marks, but I mean, remember when Prince changed his name to the symbol? So, I mean, it's much easier to say Prince than say, like, this is what it is, like the symbol that's indicating who you are. So that's kind of the difference between a word mark and a design mark, and why a word mark is more valuable, because people can say it. Okay, so the design mark is a mark without any text. The design is protected as is and cannot be materially changed from what is registered. Otherwise, the registration may not be maintained. So you can claim the color for a design mark, but normally if you want to be able to use the design mark in any color, we disclaim the color, and you submit black and white images to the PTO, and that's what's registered, that design. And so if you disclaim the color, that means you can use it in any color, just like the words. If you're not claiming any specifics with stylization, then you can use it in any format. Thing about a design mark, logos can change over time. So if you are not, if it's a logo, this is relevant, especially for small businesses, because you usually have limited budgets when you're a small business, especially when you're starting out. So design mark is not going to be as big of a priority to register. If over time it becomes something that your business is known because of, then certainly it's something that you might want to register. And then hopefully it's something that you want to keep for a while, because once you register it and put all the resources into registering it, that's the mark. You can't change it. Okay, so lastly, a composite mark. So a composite mark is a combination of a word and design element together, or a mark, like a word mark with a claim to stylization. So it has to be a specific font, and it's, it makes it so that there's a design element to the word, even though it's still just the word. The composite is protected as is. So let's say you have the logo on the side, and then the word on, the other side, like right and left lockup for a logo. That's what's protected. If you change the logo to the top and the words on the bottom, that's not what's protected. So what often happens is folks, if they have the ability to just register the word mark separately and the design, and they can put them together and use it that way. You see a lot of companies doing this where you see a logo and a word, and you see little R's in a circle, like more than one on the logo. That's because they're different elements that are registered, and they're just using them together. So it's not a composite mark, it's a word mark and a design mark put together in whatever, on whatever materials you're looking at. Okay, so here are some examples. A word mark, the plain characters, on the top here, you see Samsung and Coca-Cola. Those are very well-known marks, and it's just the words, no claim to color or stylization or anything like that. Design mark, also very well-known marks here. The Apple for Apple computers, and the Nike swoosh. And then these are composite marks. So on the left, you see IKEA. It's really just the word in a square and an oval, but the colors, that those are IKEA colors. They claim the color to that. And then the font for IKEA. So that is a composite mark because it includes words and a design element. And then the ASICS mark on the side there, they do have this particular form trademarked. And so it's their little logo and the word to the side in that font. I don't think they claim the color to this, so it can be used in any color. Okay, so this is a very helpful slide, I think, in terms of choosing your mark. And this is what we call the spectrum of distinctiveness with respect to trademarks. And so on one end, you have the red side, that's your generic marks. And then on the other hand, you have the green side, which are fanciful marks. So red is the area that you don't want to be in. Orange and yellow is okay, but then green is your ideal space to be in. So generic marks are things that are the generic terms for things like cornflakes. They're flakes made from corn. So the trademark office isn't going to allow you to register that, because then nobody could use the term cornflakes in association with cornflakes. So if something is too generic, the trademark office will say, no, this is not registrable at all. I had a client come in once, and she wanted to register family trip guides for a website. And the trademark office was like, no, that's too generic. Like, nobody could use the term family trip guides for a website that showed, tips and tricks for family trips. So if it's too generic, it cannot be registered. So then the next step up from that is something that's descriptive. It's descriptive of some sort of characteristic, function, feature, or the nature of the goods or services you're providing. So work suites, they're suites that you work in. American Airlines is an airline based in America. And these are not inherently distinctive. They are descriptive of whatever it is that you're offering, but they can become distinctive through use over time. So American Airlines, even though it is descriptive, whenever we say American Airlines, we now know it refers to this specific airline. So it can become distinctive over time, and that's when you can kind of secure your registration. You can register descriptive marks. They're just typically the trademark office will say it has to be registered on the supplemental register. There are two registries with the USPTO, the principal register and the supplemental register. So if it's not inherently distinctive, or there's some other issue with it, it's descriptive in some other way, they might say it's not registrable on the principal register, but you can register it on the supplemental. And then once you've registered it, you still do have protections under the supplemental register. But once you've used it over time and it becomes distinctive, you can apply to have it registered on the principal register, and you just have to prove that it's become distinctive. Suggestive marks are marks that make the consumer think a little bit and have to connect two ideas. So Coppertone for sun care products, Netflix for films that you can see over the internet. So those are a little bit more distinctive because they're not as, blatantly descriptive of what it is that you're providing. Arbitrary marks, these are things that can be common words, but they're used in something that is unexpected, like Apple for computers or electronic devices. When they first started, it was computers, but it's now expanded to much more. But at the time, you wouldn't associate apples with computers. So it's an arbitrary use of that mark. Same with Starbucks. It's a character in a book. Would you think of it as representing coffee? Probably not, but that's what Starbucks has done. And then fanciful marks are things that are completely made up. Usually they're things like a combination of two words like Verizon or Adidas, which was part of like the founder's first and last name. So those are things that are very strong because they're going to be distinctive because nobody else has made up the same word based for the reasons that you have. So keep this in mind when choosing your marks. So after you choose a mark, it's a good idea to assess, whether it's being used in the marketplace by somebody else. So check for existing uses of the mark and prevent potential infringement issues. Another thing the clearance search does is assesses the likelihood of registration with the PTO. There are different scopes of searches that you can undertake. You can do what's called a knockout search, which is focused primarily on the USPTO registry, but that doesn't necessarily take into account common law marks. So this kind of second level where you're searching registered and common law marks, that's a little more comprehensive of a search, and usually what I recommend to folks who are wanting to register a trademark, because the scope of the search will also include internet sources for that industry with respect to your goods and services. It'll include domain names. It'll include corporate name registries that are all state specific. So there's no one registry. It searches the whole country and all the states. And then it could also search the US registry as well. And then also state registries. It'll look at those. So all of those other things outside of the USPTO, those are what common law marks would be based on. So searching those is helpful. And then you could do a wider scope. This isn't usually necessary for our small business clients, but the way that we do the searches, we have another option where you can do the registered and common law marks in the US, but also search the copyright registry and international marks. So there are international trademark registries that you could search if it's something that you're going to take to market internationally. Usually when we do the search, we want to file an application close in time after the search, because the search is only good until the point in time where you do the search. Because something could be filed or something could, somebody could start using a mark after you've done the search. And if you wait between doing the search and filing an application, something could have happened in the interim time. So that's just something to know. And you would file the application if the search came back clear and, the risks that were identified, if any, were minimal, or things that you wanted to, that you felt comfortable with if you were to pursue an application. So the other reason why I recommend a clearance search is because of the timelines for registration. Right now, I'll just skip to the next slide here. The timeline for registration is approximately a year. But once you submit your application, it doesn't get assigned to an examining attorney for about 8 to 9 months right now. The trademark office is really backed up. So if you wanted to start using a trademark, either for your business name or a product or anything like that, you won't know for sure that it's going to be registrable for a long time, up to a year. maybe more. So having a trademark search done gives you a little bit more reassurance about the likelihood of registration. And therefore, if you want to move forward with the application and then move forward with starting to use that mark, you can do that. So another reason why a clearance search is also helpful. Okay, so
Can I ask
the
a
US,
question?
oh yes.
When you're talking about the clearance search, is that something that a business owner does on their own? Is it usually done by an attorney? Is it a combination? Like, who is doing that
That's
generally?
a great question. Thank you for raising it. So anyone can do like a Google search or just search on the trademark registry because it's a public database. There is a bit of an art to searching the database. And when you're searching, you have to keep in mind that trademarks can be considered confusingly similar, even if a trademark is slightly different, like it's spelled differently or it's in a different language. If it can create consumer confusion because of some aspect of it that is similar and creates a similar common connotation for consumers, it could be considered confusingly similar and not be able to get registration from the USPTO. And the reason I bring this up is that when you're searching the trademark registry, you might be just searching your exact mark. And there are these other things that are outside of that that could still prevent you from registering, even though your exact mark isn't registered. And then there's an analysis that goes into whether that mark is being used in association with similar or related goods or services as what you're offering. So that's another big criteria that the USPTO will look at. So the search is kind of doing a preliminary examination and of what, and it kind of mimics what the examiner will do at the PTO. So you're just kind of doing the work ahead of time to make sure that it can make it through examination. But you can do it yourself, but there are some caveats to that. There are companies that will do it. There are some companies that actually use AI to do it, and there's other companies that use real people to do it. And so there's some analysis in terms of the results. The AI companies give you a lot of results back because they're just, it's automated. So some of the information might not be helpful, but you can do it yourself. You can hire a company to do it. You can hire a law firm to do it. Our law firm actually outsources the search, and then we get a trademark search report, and then I go through it and I look through all the results and I produce a letter that basically summarizes the information and provides recommendations based on the results. So there's kind of different levels that you could undertake. You don't have to do a trademark search, but given the investment and the time that it takes to get something registered, it's good to do at least something. So thanks for that question, Kathryn. All
Thank you.
right, so on to the actual trademark prosecution process, which is the registration piece. So you get your trademark search results and you don't see any big issues, or there might be a couple of minor things that don't cause you pause. So you want to register it. So first thing is you have to prepare an application, and then it goes into the process from there. So next is examination by a trademark examining attorney, then publication, and then hopefully registration if you've passed through all the steps. So the application, you need a few things. First is the filing basis. So you can file an application based on use of the mark. You can also file an application based on an intent to use the mark. So if you're concepting things and you want to secure the rights to a name for a business or a product or your brand, you can file an application with the USPTO. So why does this help? Well, it helps because it gives you an earlier filing date. Even though the US is a first to use jurisdiction, The PTO doesn't do things like determine who has superior rights to a trademark. They only look at what's filed with them. And so having an earlier filing date could prevent others from using or filing an application for a trademark after you've already concepted it and want to decide that you want to start using the mark. So an intent to use application can be really handy to secure your rights before somebody else kind of moves into your space using the same mark. You can also have a foreign registration and use that as a filing basis. We're not going to cover that. For the most part, if you're already using the mark or intend to use a mark, you can file a trademark application. So you'll also want to have or be required to put the owner information down on your application. For the most part, I recommend having the business own the trademark application as opposed to the individual. Sometimes that might not be possible if you haven't formed a business yet. You can also assign the trademark rights to the business after the fact if you've registered it under your own name. This helps kind of on the back end in terms of trademark enforcement because the company has the rights and is using the mark. It's not the individual who should be bringing the trademark infringement claim. It's the company. So if you're using the mark in association with the company and you have a separate entity, have the entity be the owner of the trademark. You have to include a depiction of the mark, which is called a drawing. If it's a word mark, then it's literally just the word in like Times New Roman font. If it's logo, submit the logo, etc. And then importantly, the goods or services associated with the mark, you have to list these out in your application. There are 45 different classes of goods and services that the trademark office has categorized goods and services into. The first, I think, 39 are goods, and then 6 are services. And so you can determine what it is that you are, what goods or services you're providing. So interestingly, you can have more than one class of goods or services for one thing that you're doing. So podcasts, for example, you're providing like entertainment or educational services through the content in your podcast. But if it's a downloadable podcast, that downloadable electronic item is also considered a good. So you could register it in both classes. Just keep in mind that the filing fees are based on the number of classes that you registered for. So down below, you can see it's $250 per class for a T's plus application, and then $350 for a T's standard application. So the difference there between these two filing fees is the lower filing fee is if you use the pre-approved standard descriptions that the trademark office has. These are all listed in the trademark ID manual. If you Google that, it'll come up. And you can search for the standard wording that they use to describe your goods or services. If it's something that's novel or new, like technology-wise, it might not be in the standard descriptions, and then you might have to custom write your descriptions, and that's when the higher filing fee can come in if you don't find something that adequately describes what you're offering. So if possible, I always say do the 250 because if you have multiple classes, that adds up. And then I'm just going to pop back to the dates of first use and specimens that are also required for the application. So if you are filing a use-based application, you also have to say when you first used the application, and that's because of the common law in the US. And then specimens are evidence of use. So it's usually marketing materials where it's publicly viewable. So your mark and either the goods or services on a website, those are good materials for specimens. I'm going to speed it up a little bit because I'm running up on time here. So that's the application. Examination is when the trademark examining attorney gets assigned to your application, and they'll look at the application requirements. If you've met those are very minimal. Whether there's a likelihood of confusion with another mark in the registry or that's pending. other things like descriptiveness, if those are issues, and then other potential grounds for refusal. If there is an issue, they will issue you an office action to notify you as the applicant what the issue is, and then you have 3 months to respond to it, whatever it is. Sometimes it's something pretty simple. Sometimes it's something more serious and cannot be overcome. Or it's something in the middle, where you can overcome it, or you might be able to submit arguments against the finding. But that always costs a little bit more money if you need to do that type of work, because you likely will want to have an attorney do that for you. You can do it yourself. It is difficult because it's legal. You have to know the legalities of it. So if you get an office action, depending on what it is, it may or may not be able to, you may or may not be able to overcome it. So hopefully you are, and if all of the issues raised in the office action are addressed, the application proceeds to the next step, which is publication. So publication is when your application is published on the Trademark Official Gazette, and is published for 30 days. It gives notice of and provides an opportunity for anybody to oppose the registration if they think it's infringing on their mark. For the most part, this is a formality. About like 2% of applications are opposed, so not a whole lot. So for the most part, it's fine. You just have to wait 30 days. And then if no opposition is filed, the application proceeds to the next stage. If you've passed the publication stage, use-based applications, because you're already using it and you've filed your specimens and dates of use, it will just proceed to registration. So even if the publication's completed, it takes a few months for the trademark office to like process it. So it's not immediate. But if you filed an intent to use application, you'll be issued a notice of allowance. And then you have 6 months to either file a statement of use with specimens and, let them know that you started using it on whatever date. And then you have to include a filing fee per class. This is, again, if you have multiple classes, this filing fee will be more than $100. If you haven't started using your mark within 6 months, you can file a request for an extension, and each extension is 6 months each, and you can file a maximum of 5 extension requests. So this amounts to almost like 2.5 years, right? But every extension you have to pay a filing fee, of course. So you do have some time. If you haven't started using it yet in all of the classes, you can separate. If you've started using it in some classes but not others, you can proceed with some and then extend the others. Once you file the statement of use for everything, and it's accepted, or even just a part of it, it'll proceed to registration. You get a nice little e-certificate. They used to send out paper certificates, but now they don't. If you want a paper certificate that you want to frame, it costs you extra money. So most people are satisfied with the e-certificate. And then now what do? You can start using the R in a circle to give notice that your mark is a federally registered trademark, and you should update all your materials, your website, anything that your mark appears on. You want that little R in a circle in there. You paid for it, you went through the process, you suffered for it, so please use the R in a circle. Monitoring and enforcement. So what this means is you want to make sure that nobody else is infringing on your mark. If you just kind of let it go and anybody can start using your mark, then that could impair your trademark rights if you're not making sure that people aren't using your mark. So I have a question from Jean, Jean. How do you handle copyright ownership if you're using a graphic designer? That's a great question. I'm going to save it for the last slide that's coming up next. So there are trademark monitoring services that you can hire to monitor your trademark. So it's a fee. It could be an annual or a monthly fee, depending on what you choose or what they offer. But you let them know what your trademark is and their registration, and then they send you a report every month to let you know if there's anybody either trying to register your mark or using your mark. So hopefully they're searching the registrations, and or pending registrations and common law. You can probably choose the scope depending on how much how much you want to spend on the service. So that's something you can do. And then if you do find somebody who is using a mark that's similar to yours in similar related goods and services, you want to ask them to stop. So typically you start by just emailing them. You don't want to come out strong with a letter from your lawyer, but just have a conversation. You know, that almost always like just starts the process on a better on a better footing. So monitoring and enforcement are important. And then you also have to maintain your registration. Between years 5 and 6 after registration, you have to file a declaration of use. So this is a Section 8 filing. You can also file something that allows you to say that the registration is incontestable. So that is, you know, after 5 years of registration, there is a bit of a presumption that your mark has become distinctive. So if it was something that was descriptive before at the 5-year mark, if you've been using it for 5 years and people know you by it, you can file for you can file an extra document that makes it harder for anyone to challenge your registration. And that's under Section 15. So, but of the Trademark Act. So after that, it's between years 9 and 10, you have to file a declaration of use, same thing as at years 5 and 6, but then you have to apply for a renewal. And then every 10 years after that, same thing. If you're continuing to use the mark, and you have to file specimens that show that you're continuing to use the mark in the goods and services that you're registered for. Okay, so business considerations. Registering your trademarks helps protect your business and its earning potential. A few reasons here. And trademarks are intangible assets that can affect the valuation of your business. So if somebody is looking to invest in your business, if you have a registered trademark, that is an asset and it adds to the valuation of your business. Also, same thing when selling your business. So this is where Jean's question comes in. Secure the rights to trademarks and other IP created by employees, contractors, and collaborators with contracts. So if somebody has designed a logo for you, a graphic designer's designed a logo for you, you want to have a contract with them that says you own the logo, that it was a work made for hire for you or your business. And so once you own that, you are entitled to register it as a trademark. So anytime you have somebody design something for you, it's subject to copyright, because whoever create something is automatically the owner unless there is a contract that says otherwise. So you want to have a work for hire contract with the designer that gives you your copyright in the mark and all other ownership rights. And then another thing you can do is leverage your trademarks through licensing agreements that require some sort of quality control and make sure they're using the mark properly, how you want it, because how they're using it is kind of an extension of you and your reputation. So you want to make sure that it's maintained and used in the quality that you want it to. So something that big companies do very successfully, like Disney, they license their stuff to everyone. And it's all done through licensing agreements. So that could be another stream of income for you if that becomes an option. So again, just a reminder to monitor and enforce. It's all part of it, but these are just some business considerations with respect to trademarks and IP. And with that, sorry about breezing through the end there, but I've come to the conclusion of my presentation. This is my name and email. Our law firm offers other services as well as business law and trademarks. They're listed here. If you'd like a consultation about and have questions, you can have a free 20 minutes with me by signing up at this link. I'm going to give this presentation to Kathryn, and she can distribute it after the class. So with that, thank you so much for attending. I know there was a lot of information in here, so if you have questions, like I said, you can sign up for some time with me.
Thank you so much, Tammy. Let me just do a quick follow-up with the one question that came in. It was, what if the owner of the company is the designer? I think what you had explained still applies, just having an understanding as to the contract around the graphic designs and making sure it fits needs.
Sure. I mean, if it's your company, so this can depend. Like if you are a sole proprietor, then, you and the business are one and the same. If it's an LLC, you might have an operating agreement that says that, anything that you create for the business is owned by the business. Um, or you could have a separate contract that says anything that you create is owned by the business. Usually, if you have a business with multiple owners, there should be some document that says how you're operating things, and it should include things like IP and how that's treated if it's created by the owner. So for an LLC, it would be an operating agreement.
Thank you so much. And with that, Tammy does return with her teammate on Tuesday doing registering your business webinar, and quickly eyeballing. I think most, if not all of you are registered, but I still highly recommend the webinar because it does cover the various business entity types, but it also talks about the registration processes. And many businesses that we see don't register at their locality, for instance. So it does walk through some of those considerations all the way to making sure that we're keeping your social security number safe with the EIN through IRS. Lots of acronyms there. So I do want to do a plug for that webinar on Tuesday with the Geller Law Group. I think that's what I wanted to cover. So before we conclude officially, I did drop in an evaluation in the chat. This is really valuable to Tammy and myself. We want to bring content in the future that you're looking forward to, that you would find helpful. So there is a space for you to suggest future topics. We're curious as to what time of day do you prefer webinars, your experience with today's webinar, etc. So if you wouldn't mind taking about 20 seconds, it's really quick and easy. But in the meantime, while people are completing that, I will be sure that everyone does receive the recording for today. Tammy said that she's willing to offer the slides, so I'll make sure to delineate that as well too. And for the attendees, thank you so much for your presence today, your excellent questions and your engagement. Tammy, thank you so much. I know this is a complex topic, so thank you for breaking it down for us. And for your expertise today. And I think with that, I wish everybody a really great day, and we look forward to supporting the journey.
Thanks, Kathryn. Thanks,
Thank
everyone.
you so much.
Have a good one.